Lok Sabha passed 3 criminal laws: the Bharatiya Nyaya Sanhita, the Bharatiya Nagarika Suraksha Sanhita and the Bharatiya Sakshya Bill. These bills replaced the Indian Penal Code of 1860, CRPC of 1973 and the Indian Evidence Act of 1872 respectively. The 3 bills were passed even as 97 opposition Member of Parliament remained suspended from the lower house amidst protests over Parliament's security breach. Meanwhile, Union Home Minister Amit Shah said that the bills have been passed on the basis of 3 principles: a person's freedom, human rights and impartiality. He also added that the 3 new laws reflect the spirit of original Indian Code of Justice. Well, without further ado, let's have a look at these 3 bills that have been passed, what has been retrieved from the IPC, CRPC and the Indian Evidence Act, and the significance of reframing the criminal justice system of our country. Of course, to talk more about this, joining me on the show is Mr. Ashwini Dubey, senior lawyer. Advocate Sukumar Patjoshi, Vice President of the Bar Association, Supreme Court, also with us on the broadcast. And last but not the least, Joyita Basu, editor of the Sunday Guardian, with us on the show as well. I'm going to go to the big screen and try and explain to you what remains, what changes, and how impactful is that going to be when it comes to the overall sanctity of the laws that have prevailed in our country. Of course, the 3 criminal bills: the old bill, the Indian Penal Code of 1860, well, needless to say, it is from the British era. The new bill is the Bharatiya Nyaya Sanhita. It includes 358 sections instead of the IPC's 511 sections, retains most offences from the IPC. Sexual offences: the IPC criminalizes rape, voyeurism, stalking and insulting the modesty of a woman. The BNS2 retains the enlisted provisions as well from the sexual offences. Increases the threshold for the victim to be classified as a major in case of gang rape from 16 to 18 years of age. And this is a big change. It also criminalizes sexual intercourse with a woman by deceitful means or making false promises. This is something which has been retained from the IPC as well. The IPC criminalized murder, abetment of suicide, assault and causing grievous hurt. The new law, of course, retains the enlisted provisions as well, but some minor changes in language have been added on. Offence against the body adds new offences such as organisation crime, terrorism, murder or grievous hurt by a group of certain people on certain grounds. The IPC included the offence of sedition. The BNS2, of course, removes this given offence. It will be perhaps looked in a new light, if we can call it that. It penalizes the following: exciting or attempting to excite secession, armed rebellion or subversive activities which are directed towards the nation. It penalizes the following as well: it encourages feeling of separatist activities. It will be penalized. It endangers the sovereignty or unity and integrity of our country. Then it obviously is something which is going to be called an offence. The offences may involve exchange of words or signs, electronic communication or use of financial means as well. Terrorism also includes threaten the unity, the integrity, security of our country is also going to be a part of the definition of terrorism. It also includes strike terror in the people or any section of the people in India by various means. Well, the punishment for attempt to commuting terrorism includes death or life imprisonment, which is something which continues to be so. Imprisonment between 5 years and life, and of course a fine. Includes offences such as kidnapping, extortion, contract killing, land grabbing, financial scams and cybercrime carried out on behalf of a particular syndicate. Punishment for attempting committing crime also includes imprisonment between 5 years to life. It will also involve and invite imprisonment between 5 years, life and a fine of a certain amount. Compared to the IPC, the bill adds murder or grievous hurt by 5 or more people on specified grounds as an offence. It also on these grounds include race, caste, sex, language or personal belief. Punishment includes life imprisonment or death as well. The old bill, of course, the CRPC 1973, the new bill is Bharatiya Nagarika Suraksha Sanhita, and this is The new version, it also is replete with a number of changes, which of course, lend it a more modern impact. We'll have 531 sections instead of the CRPC's 484 sections, retains most of the previous provisions as well. 177 sections have been changed, 9 sections have been added, 14 sections have been repealed. The audio-video provision has been added at 35 places as well. As per CRPC, if any accused has spent half of the minimum period of imprisonment in detention, he must be released on a personal bond. And this is, of course, the detention of under trials is what we are talking about at this point in time. The BNSS 2 adds that the provision won't apply to offences punishable by life imprisonment, which of course also constitute rape and murder. It adds that the provision won't apply to people against whom proceedings are pending in more than one offence. This obviously goes back to the background as well. CRPC allows medical examination for accused in certain cases, including rape is the new provision as well. Examination done by a registered medical practitioner on the request of at least a sub-inspector level police officer is the new change that has been brought in. The BNSS 2 provides that any police officer can request such an examination, and on the behest of the police officer, this examination will be conducted. Mandates forensic investigation for offences punishable with at least 7 years of imprisonment. Forensic experts will visit crime scenes and collect evidence on mobile phones or any other electronic device as well. If a state does not have forensic facilities, it has to utilize such facility in another state. This was obviously a very murky ground in the past as well, which has been taken care of. The CRPC also empowers a magistrate to order and person to provide specimen signatures or handwriting as well in case if it's a financial fraud. The BNSS 2 expands this to include finger impressions and voice samples as well. So biometrics has also become a part of analyzing criminality. It allows these samples to be collected from a person who has not been arrested. All right, the timeline for producers, medical practitioners who examine rape to submit reports to investigating officers within 7 days. This stipulation is obviously going to expedite cases, judgments to be delivered within 30 days, extended by 40 days after completion of an argument. Big changes coming in, and the victim must be informed of the progress of the investigation within 90 days. As we all know that some of these rape cases have fallen flat when it comes to the provisions that the law has provided. Framing of charges by a session court with 60 days from first hearing on charges is something that has also been undertaken. A slew of changes. I'm going to start my questioning from Mr. Ashwini Dubey. Ashwini, if you can hear me, thank you so much for joining us here on NewsX.
Hi, thank you very much.
Well, Ashwin, correct me if I'm wrong. Basically, the overall essence, the impact as well as the efficacy of the law has been maintained, but certain lacunas and loopholes have been ironed out, because if it's 1860 when some of these laws were attributed to our nation, then obviously almost 2 centuries later, they should not be, applying to a civilization or a population, that has found problems with it.
Vineet bhai, the Lord Macaulay created the Indian Penal Code to meet the Britishers' requirements. That was not to secure justice for Indians. And it was based on the colonial perception of Britishers to rule India and on master servant attitude. Since 1860, Vineet bhai, till 2023, a lot of water had thrown under the bridge. Lot of changes needed. Pendency of cases, as law minister said in the parliament, that it was 5 crores. The lack of resources and infrastructure, the police lethargic attitude, that was not the victim centric, that was in fact the prosecution centric, and also which was the politicians were in fact dictating their own terms. The Police Act also. So if we see the law which was existing in this country, which was their power from rulers, so now this is an attempt to shift the power from the rulers to the people. And that is why the restructuring, the bringing of new laws is required. Certain laws, like you see 2023, we are dealing with the scientific investigation. We are dealing with the digital evidences. The Evidence Act, which was brought in 1872, at that point of time, there was no scientific, no forensic laboratories, nothing. Now that law was existing here. The 304A, Vinit Bhai, you see, the death caused by the negligence, maximum punishment was 2 years. यानी ब्रिटिशर की किसी की गाड़ी मोटर किसी भारतीय के ऊपर चढ़ जाए तो 2 साल तक की सजा, थाने से जमानत. So that was the need to tackle the crime like mob lynching, need to tackle the crime, financial crimes, white collar crimes, economic crimes, and that was not that were not recognized in the IPC of 1860. As rightly said, ki Indian Penal Code, Bharatiya Dand Sanhita, the Dand Sanhita was aimed to give dand. Now Nyaya Sanhita, as I understand as a student of law, and correct me if I'm wrong, you and Parjoshi sir, now the Nyaya Sanhita appears from the word itself that it is to secure the justice. But yes, it takes time because it is a reformative steps. So day by day, the new things will emerge and new changes will take. And from 1860 till 2023, when IPC was amended 77 times. And Vinit Bhai, we live in a country where maximum terrorist attack took place. But Indian Penal Code, the criminal law was not defining the terrorism. There was a special legislation, POTA, TADA, but the Indian Penal Code, that was not brought, the amendment was not brought into the Indian Penal Code. So that is what we need. We need a law which is required in today's act, which is the public centric, and there's the punishment, the grievous, see the punishment, the under trial prisoners is state of affairs, you said. So by bringing this legislation saying that the community service has to be offered by a criminal if the offense is petty. So that is the reforms which we needed, the Supreme Court for which talks about. Several minor offences, community service, the provisions made to ensure compulsory collection of forensic evidence. Audio-video recording of a statement of victim of sexual violence case was made mandatory. There was an independent directorate for prosecution. Earlier, you and the Parjoshi sir will agree, the directorate of prosecution was under the state supervision. Now there will be at least independent authority which will take a decision that whether appeal should be filed in a case where the offences are not required to be appealed. The white collar offences and also the terrorism, like the attack in India's integrity, sovereignty, security, economic security, and the spreading terror. अभी क्या होता था, किसी को सजा दे दिया तो बहुत सारे अखबार, बहुत सारी चीजें उसको कभी एक्टिविस्ट बताने लगते थे, कभी राइटर बताने लगते थे, कभी कुछ बताने लगते थे. They are talking about their fighting for their justice, fighting for their rights. यानी वो भूल जाते थे कि their act was against the country's integrity. So I think that the mob lynching, the terrorism, the offences against the women which has found place are very much required in today's scenario, and government has done a commendable job. Over to you, Vinit Bhai.
Advocate Parjoshi, the government has done a commendable job. Obviously, the syncing of these laws with the Indian penal aspirations today was becoming more difficult day by day. Do you think this is a start? And perhaps the stalled legal system of our country can find some hope in these provisions or these new provisions? So you're muted. Mr. Parjoshi, I can't hear you.
Hello.
Yeah, there you go. Go on, sir.
Yeah. Thank you. Good evening. To say the least, this is timely and an updation and a reform. This is, in fact, never seen before kind of a reform. The criminal justice system was almost crumbling. In fact, and you're hounding people for nothing. Now, in fact, the British imprint is probably not, if not totally gone, is substantially gone. And now this criminal justice system, with these changes, in fact, is much more Indianized and with the Indian ethos of Nyaya, that's the justice, the concept of justice, and not simply to hound somebody and punish. So this is the first change I see. What was ailing the criminal justice system was the delay and the procedural lapses in the investigation. That is, according to me, that is the biggest change here. it has been made time bound. In every sort of investigation, timeline is prescribed. That is, then the technology is taken into account, and it is keeping pace with the technological innovations of the criminal minds, and to check that. It is probably very futuristic, and maybe if the British law to punish Indians and those who are going against the government, so-called rulers, if it lasted so long, probably this law will last much more. And of course, since it is by Indian Parliament, it will also understand gradually more and more, and maybe that it is work towards working with the Indian system and keeping pace with the advancements. The other thing which I want to point out is earlier the law of sedition was purely somebody who is going against the establishment has to be punished. But now it is, if it is going against the interest of the country. So that's a major shift. Major law has been defined, and adequate punishment after fair trials have been prescribed here, particularly in terrorism and sexual offences. People, I think, and it is victim centric, which Ashwini said so clearly, and I'm so happy that he delineated the subject so in detail, that now the victim has a right to know the process, etc. Otherwise, it was state versus so and so only, and the victim had to make an application that can I participate in this. It was not as if not for him or her. So now that the shift is there, and I think that Bharatiyata is there. Only thing I see that it should also now be translated into various languages so that people understand this, utilize this, and the administration applies this with the correct letter and spirit. I wish that this goes in various Indian languages, in the local languages, and is applied correctly. The very essence of this change, I don't know how to describe this, and I must congratulate the present establishment for taking it up. This is a Herculean task, and everybody thought that the Britishers were so good in lawmaking. Lord Macaulay was a genius and things like that. But now I think the way the administration has worked and worked out a system for us, the criminal justice system will be for reforms and for securing justice, and not only aiming at punishing people. One thing I'll see, even if in motor vehicle accidents, there was a whole lot of law made by Britishers to punish the accused, but there was no law giving any right to the victim. And victimology was only a second, and it was a research subject only. It was never a subject of the law and law dispensation system. So this is what, for the first time, the victims are given right that you are entitled to this and you are participating in the proceedings. This is what my take on this, and I congratulate the government for bringing out such a reformative step.
Let me also get a response from Janvi Sharma on this. Janvi, if you're there with us.
Yes, hi.
Yeah, Advocate Padjoshi, in fact, did mention, about the changes and the transformation of some of the laws pertaining to rape. They have been a sore thumb, in the hand of law, and that perhaps is going to turn the wheels of justice a lot faster, because at the end of the day, the gratification of justice for the victim is everything when it comes to the legal system of any country.
Yeah, that's very true. And also, I agree with my esteemed panelists, and they've made some very, very, important points. And, we often hear this, and in debates also, we often hear that, justice delayed is justice denied. And, people always say that our criminal justice system takes too long, and the victims keep waiting, and, it takes them a while before they see justice before their own eyes. So I feel all the, the changes, the limitation periods that have been added for the procedural aspect of crimes, especially related to women, like rape and, molestation, etc. So those have sort of, moved the direction for reducing the time frame of the procedural aspect of criminal litigation. and have codified them. And also, I feel that, a lot of these issues, and this is my perspective, a lot of these issues have already been dealt with via a lot of judgments as our criminal jurisprudence has evolved. A lot of the judgments have spoken about these issues. For example, the digital era, using biometrics or using technology, using forensic labs. So all of this has been used and has been talked about in the judgments, in the body of the judgments, in observations of the court. It is now that it has been officially codified in a manner that can be implemented and can be systematic for the entire nation. Also, like Mr. Ashwini said, he talked about activism. And I do want to say that there is a very fine line between activism and anti-state. So that line, I feel, has somehow been redrawn through these bills. And for that, I truly congratulate the legislatures.
All right, on that note, we are going to take a break, but definitely this is a big and a great step, a giant leap, if we can call it, taking the words out of what Neil Armstrong said when he stepped on the moon. It's a giant leap for the Indian penal system, and this is obviously going to percolate down, translate into benefits for us, citizens of India.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.